Good afternoon. This is Greg Lois, and today we are talking about pretrials and trial practice in New Jersey. There are some handouts today in the webinar, so if you're joining us live, I hope you had an opportunity to download the handouts, which I think are going to be useful for you going forward. But my goal is to talk about pretrial practice and then trial practice in New Jersey. I want to demystify as much of that as I can. I want to talk about tactics and strategy. I want to talk about some practical things you can do to move your cases forward in this jurisdiction, which doesn't always move at a fast pace. And I want to talk about some out-of-the-box or creative ideas that we have for moving cases forward and making sure you get the best outcome if you choose to try your case. So let's jump into today's presentation. Remember, this is for instructional purposes only, and I'm not providing legal advice as to any particular matter. Come on, guys, you know I'm an attorney. I got to give you those disclaimers. All right, our mission here at LOIS Law Firm, all we do is workers' compensation defense. We're more than 50 attorneys, and we all are on the same mission. In New Jersey, our mission is to take control and stay in control of that New Jersey workers' compensation case. Our goal is to drive these cases to closure as efficiently and as effectively as possible. Now, some of the things I'm going to be talking about today are coming from the rules of court, so I'm going to make references to those where they are important or necessary. Some of the rules that we're going to talk about today come from the statute, and my goal is to explain to you how we apply this theory and how we make sure that we're deploying the correct discovery and litigation tactics to move these cases forward as quickly as possible. Today's presentation is going to be roughly coextant with the book I wrote with Rick Rubenstein called The New Jersey Workers' Compensation Practice Guide. And in today's handouts, there are some materials from that book. This is really the Bible of workers' compensation in New Jersey. I'm a defense attorney. I wrote all the aspects of the book that have to do with the defense side of things. And then Rick Rubenstein, who's an amazing petitioner's attorney, wrote the other half of the book looking at things from a petitioner's perspective. We think it gives a very holistic and comprehensive view of the practice of workers' compensation in this jurisdiction. Today's presentation, we're going to talk about pretrial conferences leading into a pretrial memorandum. I'm going to explain what that means. And then I'm going to talk about the order of proofs and trial. And I'm going to skip the section on accelerated awards processing. That really doesn't take place that much anymore, and it's not that pertinent to today's discussion. Now, I want to just start by stressing off that pretrial conferences are just one way to get cases moving. And what we've discovered in the last 5 or 6 years is that pretrial conferences have become increasingly useless in this jurisdiction. And there's a lot of reasons for that. There's a lot of, I believe, institutional lethargy. But if you're wondering, why are my workers' compensation cases in New Jersey moving slower than ever? The reason is, again, there's just this bias towards adjourning things and delaying things, and it's extremely frustrating. Well, what I want to talk about today is how do we break through that logjam? How do we move cases forward? What should we be doing at those pretrial conferences and then at those trials if they need to take place? And my idea here is always we want to start with the end in sight. We want to start with our goals in our cases. So that's what we're going to be talking about today, trying to route around a system which is not working well, particularly from the defense or respondent's perspective. And I'll answer any questions you have about what we're seeing. Let me just start very quickly by talking about New Jersey's unique court hearing cycle concept. New Jersey has what's called a circular docket. Every case just gets adjourned for a very specific number of weeks. And where does that come from? Well, it's got a hearing cycle concept. We don't have like a trailing docket type of concept here. The courts work on a 21-day hearing cycle divided into 3 days of 5 days each. So when a case gets adjourned by a court, and by the way, every case gets listed for a pretrial conference. That doesn't really mean anything. It just really means a judge is going to sit in a status conference update. When a judge adjourns it, or when the case gets adjourned, the judge can adjourn it a minimum of 3 weeks. That's one cycle. And what this introduces is a high degree of predictability as to when your cases are going to be listed for proceedings. And every respondent in the state of New Jersey is assigned, once you have a sizable enough hearing list, you're going to be assigned specific days in front of specific judges in your hearing cycle. And here's our LOIS Law Firm hearing cycle. And these are the judges that we regularly appear before. Today in the handouts, I included a day calculator which helps you to understand how the system works. If a case was listed today is the 2-1 cycle day. If it gets adjourned, if it gets adjourned one cycle, it will be adjourned to June 23. That's just 21 days from today. If it's adjourned 2 cycles, it'll be moved to July 14th, 2025. And if you look at that hearing calculator, which I've included again in today's handouts, you'll discover there's a lot of dates that are blued out because those are either court holidays or court recesses. Now, there are some advantages to this type of docketing system. There's a lot of predictability to it. We know when the case can be adjourned to and when it's next going to be heard, which is useful. And if a case does get adjourned, we should be telling you exactly when you can expect to have it listed. Because we have a cycle date before an individual judge in every single hearing point in the state of New Jersey, that means we can also go to that judge and say, hey, judge, I need you to add this case on. We've reached a settlement, and we'd like you to put that case on for a settlement. That's awesome, right? Because that means if you reach a settlement, you don't have to wait until the next possible listing date. That could be months away. Instead, you can contact the judge, generally very informally. Some of the judges are so amenable to this that they'll say, hey, look, anytime you want, you can add on a case. And they're very amenable to helping us reach those resolutions. So this is not a jurisdiction that you should generally be waiting for settlements to be put through on the record. You should be able to get those settlements resolved very quickly and easily. Nearly all the courts are going virtual now or semi-virtual. And in every court, you are allowed to present any testimony you want virtually, including doctors. However, this is very uneven throughout the different courts. There are 15 different vicinages in New Jersey workers' compensation, 15 different hearing points to think of them that way. In those hearing points, some of them have 1, 2, 3, 4, some up to 4 or 5 judges assigned to those hearing points. And every judge is allowed to set their own standard for how they handle hearings, whether it's phone calls, whether it's in person, whether it's on Teams, whether it's on WebEx, whether it's on anything. The chief judge seems to be trying to push all the judges towards handling matters on Teams, but just understand this is very judge by judge. Also, in the old days, we used to appear in court. I mean, when I say old days, I mean 5 years ago. We used to appear in court. The judge would call the calendar and get markings from both sides at the call of the list. That is happening less frequently now. Judges are doing a lot of that over email. So the practice has certainly changed in the last 5 years. We can thank COVID lockdowns for that. Some best practices for managing this docketing system here at LOIS. 2 weeks before any case is listed in court, our paralegal is going to fully prepare that matter, look for what's missing, what can be moved, what are we waiting for from the other side. We're going to be contacting opposing counsel. We might be contacting the court to get matters moved or listed, and we're going to be sending you, the client or the insured, an email saying, here's what we think is going to happen. A week before the listing, the attorney is going to review the matter and make sure that everything is ready so that we're going to have a successful conference with the judge. We're going to have a successful pretrial experience with the court, and we're going to be reporting to our client. Our standard practice here is the day after every single hearing, you will get a post-hearing report from the handling attorney, the assigned attorney, I should say, and they're going to tell you exactly what happened in court and what our next actions are going to be, what we should do next, right? Because we're always thinking about how we're going to proactively stay in control of this case and move this case to closure, right? That's our goal. Pretrial conferences are something that are kind of a misnomer. It doesn't mean the case is actually going to trial. They really should be called status conferences or compliance conferences. It's simply a conference of all the parties. Most judges are doing these via web conference. Again, no standard for that. The parties are generally saying, hey, judge, I'm ready to move forward, or I'm not ready to move forward. Judge, I'm waiting for this. They're supposed to discuss issues with the judge. And in my experience, and I've been doing this for more than 20 years, this is where a lot of cases got settled. They got settled informally between the parties talking, saying, hey, where you stand, here's where we stand, here's what our information is. And that's where cases used to be resolved. Unfortunately, those pretrial conferences are not happening between the parties. They are happening generally with a judge present, and so not so much cases being resolved that way. What are the results of a pretrial conference? What can you expect to walk out of court with when a case is listed for one of these pretrial conferences? Well, and generally nothing. The vast majority of pretrial conferences or even motion listings result in absolutely nothing being filed, no orders being issued, nothing being resolved. Generally, discussions occur between the parties. Sometimes there is input from the judge, but there is not, you should not expect in a pretrial conference scenario to walk out of court with any type of order or direction or compliance memorandum or anything. Now, the one exception to that is if a case is going to be set down for trial, the parties must execute what's called a pretrial memorandum, also called a green sheet. That pretrial memorandum, by the way, it's called a green sheet because it used to be on green paper. That's the only reason it's called the green sheet. That's the only formal result of a pretrial conference that can occur. Once a case is set down on a pretrial memorandum, that means both parties are coming to the court, they're identifying their witnesses, their proofs, their arguments, we're setting out what are the issues in dispute, then the case can be tried. And there are some very specific rules regarding these pretrial memorandums. And by the way, if you're a client or an insured out there that's listening to this, that's a really important document. That's a milestone document in your New Jersey workers' compensation case. It means there's a dispute or an issue that cannot be resolved, could not be resolved amicably or amenably. And so now we're going to try that issue or the entire case, right? It's not limited to just one issue in the case. We could try the entire case. You should be saying to counsel, hey, where's the pretrial memorandum? What's on the green sheet? And I'll tell you why in a few seconds. So that pretrial memorandum does require all the parties to disclose specifically any information that they are intending to develop during the trial. Documents, exhibits, evidence, anything we're going to produce, including, by the way, if you have surveillance that you're going to disclose at trial. Now, you don't have to turn over the surveillance or the covert video or the social media videos that you've obtained. You just have to let the other party know that I am going to be presenting that. Now, the parties are also supposed to list all the stipulations they can make. And now on your screen, you can see an exemplar of a pretrial memorandum. Again, this is one of the very few forms in workers' compensation that are actually required. This is required by the court rules to be completed before a case can be set down for trial. The parties should list all the stipulations. Everything that we can agree to or that we know in advance, we should put on the screen sheet. For example, we admit it's a stipulated accident. It involved the right hand. It occurred on the date of loss. Here was the average weekly wage. You're going to want to resolve as much as you possibly can. Both parties have to list all of the witnesses they intend on calling at trial, and that includes potential witnesses, which will become key in the next slide. The judge must also put their recommendation on the memorandum. Now, this is important, right? Because the judge has to put down on this pretrial memorandum what they're telling the parties. Oftentimes, this is going to be the judge's opinion of valuation of the case, because that's such a common issue in dispute. Hey, judge, my expert says the person has total disability. The other expert says they have no disability, right? So the two parties have this big dispute or this gulf or this gap between what the experts opine. The judge will typically say, well, your doctor says 100%, your doctor says 0%. I think the real amount of disability is 30%. And they are required to write down their recommendation on the green sheet. So if you, as the client or the insured or the carrier, is saying what happened in that pretrial conference and what's going to happen at trial, well, you're going to get a big hint from the judge because they are required to put their recommendation down on those green sheets. Every green sheet, we think this is best practice, we put down that we reserve the right to present any documentary evidence or testimony necessary to refute the claims of the petitioner. Now, I do this because in every case, I may or may not have covert surveillance. I may or may not have social media impeachment evidence or credibility evidence. I may or may not have it. But I always reserve on every single green sheet my opportunity to develop that information and bring it into the case. This gives us an open door so that we can bring in as much information as we want. Do we have to disclose that information if we don't want to use it? Absolutely not. And so tactically, I think this should be included on every pretrial memorandum. I think it's a best practice. It should be done by everyone. Also on the green sheet, we reserve our right to bring additional employer witnesses, usually at least 2, without naming with specificity those witnesses. That's so if the claimant comes into court and starts saying all sorts of things like, oh, my supervisor knew how bad I was injured and it was such a significant injury, and they're trying to create these sympathy acts, that we are able to bring rebuttal testimony in. So we're opening those doors. So remember, think about the green sheet two or three ways. First, it's going to give you some anchoring information. Here's what the judge's opinion was. Two, think about it as limiting the other side's proofs. I've successfully argued that where the other side did not list a document or a witness on their green sheet, that witness should be excluded. And the third thing we should be thinking about is how do we keep the door open so we can bring in as much contradictory evidence as we want to or need to successfully defend this case. So those are some best practices to deploy. Let's talk a little bit about how we prepare for a pretrial conference. And now I want you to think of, when I say the word pretrial conference, I want you to remember most of these are just status conferences or compliance conferences with the judge present. First, we need to have a strong understanding of all of the jurisdictional issues that we are going to raise, the issues that are going to be resolved in the case, or the issues that we can stipulate to. Most accidents, again, specific admitted accidents, we're going to admit to a lot of things. What's the date of the accident? What were the wages? What was the rate? How much did we already pay this person? Were they my employee or not? Did we receive notice of the accident? Is the injury causally related to the subject accident? And did the accident injuries arise out of in the course of employment? All of those things we should know in advance. Those should be relatively known, and we should be putting them into that pretrial conference. That is table stakes. We should also be challenging, if there are medical evaluations, whether or not those medical evaluations were done timely or too soon or too late, and whether they have become stale. There is case law in this jurisdiction that says when a medical expert's opinion was created based on information that's more than 2 years old, it may be stale and therefore useless. And that's important because sometimes the opposing counsel brings in this report and they want to challenge you with it. And you say, wait a second, this report's old. It's based on stale information. The other thing you can do is challenge that the report was made too soon after the claimant reached maximum medical improvement. You can say, look, the person did not have the benefit of full recovery. Your report is inappropriate. So there are opportunities here to exclude the other side's reports. Now, there are limitations to the amount that can be paid to the petitioner's expert, and this is very important for us to recognize. Now, these limitations were just changed a few years ago to increase them from $600 to $1,000. But the evaluating physicians relied upon by the petitioner's bench can be paid no more than $1,000 for their evaluating opinion and no more than $400 to come into court and testify. Okay, and that's for their paid experts. What this has led to is sort of a problem in this jurisdiction, which is there are just not many doctors who are providing permanency opinions, particularly on behalf of petitioners. We see the same doctors over and over and over again, and there are generally doctors who have basically committed their entire practice to doing permanent disability estimations for the claimants. The truth is, we've seen them all 1,000 times. It's actually kind of a benefit to us because we know exactly how to cross-examine them, where their weakness and vulnerabilities are, which I'll talk about a little bit later. But unfortunately, the lack of high compensation for these physicians means there's not a lot. And this leads to delay and slowness in this jurisdiction. There's not a lot of doctors that are going to say, hey, I'm going to be willing to write a report, review medicals, perform a physical examination, and then come into court and testify for only $1,400 because that's the max they can get paid. And so that means with very few physicians that are doing these examinations on behalf of petitioner, that there can be a lengthy delay between the time of the petitioner reaching maximum medical improvement and then their attorney being able to schedule them for their expert report. And that can slow down and delay these cases. So this is a two-edged sword. Now, treating doctors, there's a lot more leeway. Treating doctors can be paid up to $450 for a report, as well as up to $2,500 to come into court and testify. Now, I think this is an opportunity for us. I think that we should be relying more on treating physicians to write permanency evaluations in particular, because that's the doctor who treated the claimant, and they're more likely to find that the claimant has a low degree of residual disability, right? I mean, that makes sense. The treating physician is the person who took care of them, and they're going to write a report saying, yeah, I did a good job. They're healed. They're in great shape. They're ready to go and win in the Olympics, versus the paid expert who is, soliciting work and living off of finding high degrees of permanent residual disability. So again, this is an option and an opportunity for us on the defense side. Both sides are allowed to send letters or correspond with their selected experts. just note that these directional letters are absolutely discoverable. In our practice, before we voir dire the opponent's doctor, we're going to subpoena everything that has ever been sent to them by petitioner's attorney, right? I'm going to look and ask, what were you provided? What were you told? What was the directional letter that petitioner's counsel sent to you? That is going to come into the case, and that might form the basis of my cross-examination of their doctor. So be mindful about that. And it works the other way too. Anything that we send to our examining physician is also discoverable. And for that reason, we want to be neutral, fair, upfront. We don't want to be too biased or push our doctor too hard in any one direction, because remember, if their opinion is based on a misleading or persuasive directional letter, that may ultimately come out in trial, which would be used to impeach or reduce the credibility of our experts. So we've got to be thoughtful about how we play that game. And if you want to have a little bit of fun, just remember that the petitioners do prepare for their examinations with our physicians. If you want to have a little fun, go on YouTube and you can watch many videos about how you should be preparing yourself to go for a defense medical examination. Particularly, you just look for in this state, just look for in New Jersey. I'm sure you will find it quite humorous, the type of advice that they're being given and the way they're being set up for those exams. Now, how do we prepare for these pretrials? First, we got to know the case. We have to know the medicals cold. Our case counts are much lower, and this is an advantage. In fact, I just talked about it with this morning firm-wide. One of our big advantages on the defense is we only have a handful of cases. 60, 70, 80, 90 cases for a defense attorney. That's a very manageable caseload, as opposed to opposing counsel, which have several hundred and maybe thousands of cases assigned to them. They can't possibly know their case as well as we do. We have this huge advantage that we should be taking advantage of. We also know that the judges are going to focus more on treating records and functional outcomes than they are going to be on relying on our medical experts. So we got to know the medicals. What was the treatment course? How invasive was the care? How did they recover? I'll tell you that I think it's much more persuasive to a judge of compensation when the physical therapist says, hey, they have full range of motion and they've got their strength returned, versus whatever the paid expert is saying in regards to their function or range of motion. They're going to look at what the treating physicians say. And this is a jurisdiction where the judges will actually review the treating records and use that in the fundus of their opinion. So that's very important for us to recognize that judges generally do not just rely on expert testimony. They will review the medicals, and particularly all the medicals that are moved into evidence. Now, I believe it's best practice to spend time with our experts before they testify. I'm going to have some slides about exactly how we should do that. And I also want to remind everyone, I'll just keep saying this over and over again, no case should ever be on the trial list without a green sheet being executed. Again, you're going to want to do this because it constrains your opponent. If they don't list a witness or a document or an exhibit on that green sheet, I'm going to challenge the introduction of that issue or that document in court. And that's very important for us in limiting their proofs. Now, there's also some jurisdictional issues that have to be resolved in that pretrial memorandum, again, before the case can be tried. We want to use this opportunity to focus the judge on what issues we think are most important. We want to frame and couch the case in a way that's as favorable to our client as we possibly can be. And sometimes you'll see in cases a traumatic accident, terrible accident, dramatic traumatic accident, right? Maybe an accident that would engender a lot of sympathy. But they had great medical care, they had great outcomes, and they're back to work doing the same job in the same industry, maybe working even harder, meaning more hours or producing more. Well, we're going to want to focus on the functional outcome and not the specifics of the injury, right? The thing that's going to generate sympathy. Because we're going to say, Judge, what we compensate here is the functional ability of the claimant, not how traumatic the accident was or how many surgeries they had. Of course, in this jurisdiction, though, what typically happens is judges look at lost time from work, how much medical care, and how invasive that care is to come up with their opinion as to how much permanent residual disability is. Now, I think that's totally wrong, and that's challengeable, by the way, very much on appeal, but you've got to lay the basis for that, and this is how we do it. So you want to frame that as best you can. Of course, every time a case comes to a milestone, that's going to have an impact on the overall exposure in this case. as the permanency evaluations are conducted, as medicals are coming in, as the person's returning to work. All of that changes our exposure in the case. And also remember, the judge is expected to put their recommendations on the green sheet. That's an anchoring figure. Now, that can be discounted because maybe you have more information than the judge has. For example, the judge is just looking at medical experts and treating medicals and saying, well, here's my valuation of the case. That's great. But if you know you have covert information, you've got social media information, you've got great covert video that nobody else knows about, well, you know, hey, Judge, I understand that now you're putting a 30% of permanent partial total award on this case. But once the trial testimony goes in and I show you the video of them jumping on a trampoline and going skiing and doing all these fun things, that's going to reduce your evaluation, right? So you will sometimes have much more information than the other party because you're using that disclosure as an opportunity to contradict or challenge the credibility of the claimant. But our opinion or our best practice here is that we're going to try to keep you as updated as we can as the case is developing so that you can know what your future money exposure is going to be. By the way, these cases always come down to money. Settlement authority. When I talk to you about settlement authority, I'm always going to talk about what's the percentage of disability, but I'm going to give you the numbers. And I'm going to try to tell you exactly what is my prediction for fresh money moving. Now, the judge does have discretion to award counsel fees up to 25% and costs as well. So that can sometimes move the overall final figure a little bit. But we're going to give you our best estimate as the case is developing as to exactly how much money we think is going to move. We're also going to tell you, hey, are we going to get a credit here? Is there a reduction in the award because of a pre-existing disability? Is there an opportunity for risk transfer? And we're also going to warn you if the type of settlement that we're recommending is possible to be reopened. And just remember, every settlement via Section 22 of the statute or order approving settlement will be potentially reopened. In my opinion, reopeners are the scourge of New Jersey. Every case seems to reopen. It is a torture. We've tried every strategy you can, including doing Section 20s for the first time for even more than the case is valued to try to stave off or fend off those future reopeners. The judges are very biased against doing Section 20s. It is a jurisdictional reality that we have to deal with. And by the way, if you're like, what's a Section 20? That's a lump sum dismissal with no possibility of reopener, which is our preferred way of closing cases because it is closed with finality. Unfortunately, this jurisdiction has a bias against doing that. Now, sometimes at a pretrial conference, there will be a discussion of settlement and potential resolution. Our best practice is that every time we receive a demand, even if we don't have settlement authority and cannot make a counteroffer, our opinion is we're going to confirm that in writing with opposing counsel. We don't expect the judge to take notes or remember the settlement discussions. In fact, we probably don't want them to if those demands are made in front of the judge. And every time I make an offer, I'm also going to do it in writing, even if it's an oral offer made during a pretrial conference, so that we're very clear with opposing counsel exactly what we offered, and there can be no grounds for misinterpretation. Now, the judge will often give their own input into the settlement of a workers' compensation case. Everybody has their own style about this, and some people welcome the contributions of the judges. In general, I find the judges to be quite liberal. Remember, it's very easy to spend somebody else's money. Believe me, it's very easy to spend money when you didn't have to earn that money and it doesn't affect your bottom line. So I generally think that most judges are going to come in a lot higher than me. Now, I'm a defense attorney. I've been doing this for over 20 years. It's all I've ever done. You know what my bias is. I'm telling you, I'm going to come in a lot lower than certainly opposing counsel and most of the times, most workers' compensation judges. My position is I refuse to conference cases for the first time with the judge, meaning for the first time talking turkey dollars with the judge present, because I think I'm going to have two people arguing against me. It's not going to be just me versus opposing counsel. Now the judge is going to give their opinion. And let me tell you something, once the judge opines, your new adversary is the judge's ego, because, you know, they're wearing that robe. They're always right, right? So you're kind of introducing, in my opinion, a third factor that is going to complicate your resolution of this case. Also, getting the judge's input when you have something in your back pocket, typically covert surveillance, just be mindful that the judge is not going to be able to give you a good, meaningful estimate of overall residual disability because they don't know what you know. You also have to be thoughtful about the judge's bias and style. You got to prepare for this. Know that some judges are just going to find some disabilities or injuries more highly compensated than others. You also need to know some basic things about this jurisdiction, like cases that are in South Jersey are just, the judges are just a lot more liberal. They're going to find a higher number. Cases in North Jersey are going to be generally a little bit less. You got to know all of the ins and outs of this jurisdiction and avoid those traps. Also, counsel needs to be very mindful that the compensation awards in this jurisdiction are not linear. There are specific breakpoints in the permanency awards. So for example, 31% of partial total, sometimes called the first hump on the chart, is compensated at a much higher rate than 30% of partial total and will yield a much higher award. So we've got to be mindful about the way the compensation is calculated. This is a jurisdiction in which awards ramp up very quickly and can get quite high. Also, occupational exposures do not stack on top of each other. So when you have those claims where the person's alleging that they had occupational exposure or cumulative repetitive trauma, those disability awards should not stack, which means they should not get very high at all. Some follow-up procedures. Our goal is as soon as the pretrial conference is over, we are going to send you a post-hearing report within 1 business day. Any offer or demand that occurred in that conference, we're going to confirm that in writing, and we're going to come up with our next actions. What are we going to do next to move this case to closure? That's always our focus, to do most of our work outside of the court proceedings. And I want to stress that in the old days, and I'm talking about 5 or 6 years ago, it was possible to get great momentum or traction in your case being attentive, being proactive, going to pretrial conferences, making your arguments, meeting with opposing counsel. And I did most of my work in the benches, in the waiting rooms outside of court chambers with opposing counsel, negotiating and resolving issues and getting to settlements. That's not possible now in a virtual world. In a virtual world, if you're going to a pretrial conference hoping that maybe you'll grab the ear of opposing counsel and you'll come to an accord, that's unlikely. You've got to do all that work before the pretrial conference. So preparation is really going to be the key nowadays to being successful in the pretrials. Most of the attorney's work, most of the work of defense, most of the work of the examiner should be done before the pretrial, not at it, because those pretrials are unpredictable. We've literally had judges who stack up their calendar and don't get to cases. Judges who don't even appear virtually when they're supposed to appear. Judges who just adjourn everything. So there's lots of barriers to getting momentum or traction at those pretrial conferences. I would warn you, the world has changed. Since lockdowns, things have moved a lot slower and been a lot less pretrial conference oriented. The practice has had to change, so you've got to change with it. All right, let's talk about trial. I believe in this jurisdiction there are not enough trials. Less than 1% of all cases go to trial and get decided. Why is that? Well, there's jurisdictional bias against it. Trials are kind of long and annoying in this jurisdiction, but this is where you can get your work done if you cannot reach an accord. So let's talk about trials. First, attorneys have to be in good standing. I cannot tell you how many times I have had an ineligible opponent because they did not do their CLE or pay their lawyer's dues on time. So always check that ineligible list to make sure that this person is actually eligible to represent their own client. Be thoughtful too about cases that go onto the trial calendar. Just because a case is going to put on the trial calendar doesn't mean it's going to be reached with any kind of alacrity or priority. Chronologically, oldest cases are scheduled for trial first, and this is a jurisdiction where a lot of trials are backed up, and a lot of judges have an active trial calendar where things are getting pushed out into the distant future. In addition, judges are required to give priority to motions for med in temp over trials, and so sometimes your trial can get crowded out by this. The chief judge is the one who drives this and will have a closure focus. Most testimony takes place at 1:30 p.m., although I've seen more and more things listed for 11 or 11:30 a.m. And the schedule of the trial is really dependent on expert witness availability, which I'm going to talk about in a second. Now, the court has court rules that are supposed to control how proceedings take place before this court. And the court rule says The order of proofs shall be, in other words, how the case is supposed to be developed on the court record. This begins with the appearances of opposing parties, the stipulations of any fact or law that can be made, any rulings on motions which have not yet been ruled on, opening statements by both sides, and then the testimony of the petitioner. Generally speaking, at the first trial date, the testimony of the petitioner will be the focus of that day. After the petitioner testifies, they are allowed to bring lay witnesses, and then we are allowed to bring rebuttal lay witnesses. Although in most cases, something like 70% of cases, there are no lay witnesses. I should also remark that lay witnesses should not include members of the petitioner's family, ever. There's no good reason for them to testify in these cases if the petitioner is available and competent to testify. Next, the petitioner, now I'm up to number 8, will give testimony from their non-medical expert witnesses, which generally never happens, and then our non-medical witnesses, testimony of the treating medical experts. Now, the treating physicians rarely testify in a New Jersey workers' compensation case. I would love to change that. The treating physicians generally don't testify because they're treating doctors, and they do not want to waste time that they could spend treating an actual patient with coming to court and testifying. However, testifying in court now is easier than ever because most testimony of experts, if not all of it, in fact, in the last 2 or 3 years, I think I've done one doctor in person. It takes place over WebEx or Teams. So this is not asking the doctor to give up an entire afternoon to sit in a courtroom and not be called. In general, the judges will schedule their testimony for time certain and actually take their testimony at that time. So again, I think treating doctors should be brought into these cases more frequently. Next, the petitioner's medical expert. Again, this is their paid hired gun, and then our medical experts. At the conclusion of trial, the judge will rule on any motions. Those will probably be motions either for dismissal by us or a motion for the judge to find fraud under section 57.4. And then closing statements and post-trial briefs. And I should remark that in this jurisdiction, post-trial briefs are optional. Post-trial briefs must be submitted within 15 days of the close of proofs, and the opposing party has 7 days to put in a rebuttal brief if they disagree with what was put in the primary conclusory or trial brief by generally the respondent. I think it's best practice to file a trial brief in every case. One, it gives you an opportunity to educate the court and explain, here's why you should rule in my favor, and also it sets you up for the appeal if an appeal needs to be taken. So that's a lot of information, but I've tried to make it simple by putting the trial proofs and speed of how quickly these matters get reached and the cost into a handy-dandy chart for you. So the trial segment, first thing, petitioner testifies. Generally, that's going to be set up and heard very quickly. The petitioner should be available to prosecute their case. Usually with a 1 or 2 cycle adjournment, the judge will be command the petitioner to come in and testify. Cost, very cheap, really just the cost of a court reporter. Next, employer witnesses, rebuttal witnesses. Again, those could even be scheduled in general for the same day that the petitioner testifies. And again, rather cheap. This is not costly. The next party that testifies or person who testifies is generally the petitioner's IME doctor or doctors. And this is where the case starts to slow down because these doctors are going to need to be scheduled in, and some of them might require a few months of an advance notice to be able to schedule in. And there's going to be some cost associated with this, at least $1,000 for the report plus $400 to testify. The petitioner's treating doctor can testify next. And again, that's going to be very slow because most treating doctors are busy. However, they can be paid up to $3,500 for writing a pretrial report and also coming and testifying. So that should motivate them to want to come and be part of the case. And then the last party that testifies, or last person I should say, is usually the respondent's doctor or doctors. How the speed of this is going to be dependent on the respondent doctor's availability, and sometimes this can take a few months, and it's going to be costly. Now, I put in this chart that it costs $1,000 and up, but the truth is it's going to cost a few $1,000s, up to $5,000 or $6,000 or $7,000 for them to come in for an afternoon and testify. So be mindful of the cost of that testimony as well as the delay. So now, the other thing I should remark is that as the case goes through all these steps and and this is going to be non-continuous, so it's not like a case is going to start on a Monday and then continue on to a Tuesday, Wednesday. In between, the judge is going to adjourn it for each individual witness to come forward and testify. Those are all opportunities or milestones for case resolution. You know, the petitioner comes and testifies. They don't testify that well. You confront them with your covert information or your surveillance, and all of a sudden their case is not worth so much. Maybe you can reach a settlement. So most cases, we start by taking the testimony of the petitioner, maybe do a lay witness, and then settlement negotiations resume. So that's most cases that I've tried over the course of my career, and it's not hundreds, it's probably thousands at this point, resolve after the petitioner testifies. So keep that in mind, that these milestones are all opportunities for settlement. Now, some things to keep in mind: know the rules of evidence. Very important in a workers' compensation case. There is a difference between documents and information that's marked for identification versus moved into evidence. The defense attorney has to be able to manage the marked exhibits list, managing all of the exhibits and the things that we're going to be confronting opposing parties with. And also recognize that some judges are going to have different preferences for how they run their courtroom. Some will allow me to move documents into evidence at the conclusion of every single trial day. Some want to wait for the conclusion of the entire trial so they can hear all the evidentiary exceptions or objections at the same time. You just got to know your judge and know the jurisdiction. How do we examine the petitioner under oath? What are we doing when we're trying to cross-examine them? Well, when they're being directly examined by their own attorney, I want to use my objections and limiting stipulations as much as possible, okay? And here's how I do it. You know, particularly in a case where you've got a traumatic or dramatic accident with a severe or gruesome injury, but a pretty good outcome after medical treatment and a resumption of gainful employment. I want to stipulate to the accident. My position is I want to reduce the amount of sympathy. I want to reduce the trial time. Let's be efficient. And I'll say, Judge, look, we stipulated to the accident. Opposing counsel should not be asking them about the particulars of how much did it hurt and how much pain were you in and how gruesome was the injury and can you show me pictures of the injury? Who cares? I stipulated to the injury, Your Honor. And what I'm trying to do there is try to reduce the sympathy and subjective factors in the case. Okay, that's what we're going to do. That's the art of how we protect you during a direct examination. We also have to protect against open questions asked by opposing counsel. More and more frequently, I've heard counsel ask questions like at the conclusion of the testimony, and again, just to draw sympathy, they'll say something like, plaintiff, if there's one thing you could change in your life, what would it be? And of course, the plaintiff has already been coached to say, oh, this terrible accident which changed my whole life and it was the worst thing that ever could have happened to me in my whole experience. What is the point of that question? That question is simply to engender sympathy in the judge, right? It's not appropriate in a workers' compensation context. We're not supposed to be giving awards here for pain and suffering. And so we have to be very savvy as defense counsel to make sure that kind of stuff doesn't happen. So we're going to be ready to challenge that. Now, when we're cross-examining the petitioner, my goal is to develop information that's going to help bolster my defense, to impeach their credibility, to prepare the groundwork for our experts. And if I have covert surveillance or surprise evidence, which, by the way, I did make a blanket exception for on the green sheet, I'm going to be prepared to confront opposing counsel, confront the plaintiff with that evidence. And we are very good at making sure that we pin them down before we spring the trap, and that trap is often covert surveillance. Now, in certain types of cases, there are no experts, just lay witnesses. For example, medical provider claims, which, by the way, more of those should be tried to conclusion. Not enough of those are tried to conclusion. But there is a specific pattern that we have for defending those. Now, after the petitioner testifies, the treating physicians are supposed to testify. And this is an opportunity for us. And I just want to stress this again. If you're out there and you're not happy with the results you're getting at trial, my argument is we should be bringing in more treating physicians, particularly in big cases, particularly in cases involving perhaps total disability or significant levels of disability, perhaps over 33% or 35%. We should be bringing in treating experts. It might be more cost effective to do that than the other ways that we've been trying cases in the past. I would also say if you want to save some money, consider the use of record reviews or reports by treating physicians at the conclusion of or at maximum medical improvement. Now, petitioners evaluating physicians would then testify. These are, of course, selected by opposing counsel to provide reports. Why are they being picked? Because they're going to provide high numbers. There's nothing more to it than that. These are not good doctors. They're not practicing doctors. They're not better credentialed than the physicians that treated the claimant. They're not experts in anything at all. They are just people that come up with high numbers. That's it. And we have to draw that out in their cross-examination, which I'll talk about in a second. Now, they're usually pretty good at testifying because basically this is their only job. I try to shut them down as much as I possibly can. One of my tactics is when the petitioner's attorney says, all right, did you examine the claimant and what did you find? I say, stop. Your Honor, can we just pretend, can we have the entire expert report just read into the evidence and we'll deem it as read so they don't have to go through their entire report and we can go right into their findings, right? So what I'm trying to do there is disrupt them. I am trying to get the case to focus on just the issues in dispute, and I am trying to move into the challenging part of the testimony, which is the cross-examination. You also have to be very careful during the direct examination of their experts. Any hypotheticals or new information that's being provided to them by opposing counsel, there's always this opportunity for them to try to expand their report or find new findings or explain away discrepancies, particularly after I've already introduced covert or surveillance information. We can't let them do that. So we've got to really take control here. And we've got to cross-examine them ably. You can't cross-examine their expert unless you know more about the condition and body part than they do. Oftentimes, I will, particularly in cases that involve unique injury or an injury that's less common, I'll use my expert to help me craft my cross-examination of their expert. I will certainly provide their expert's report to my expert. I'll have my expert review it, and they'll give me great information. Sometimes they'll point me to studies or information or publish things in journals that I can then use to attack the credibility and the findings of their expert. We should also be looking at their prior testimony. In Lois Law Firm, we have not hundreds, but maybe thousands of transcripts of the usual players, the usual doctors used by opposing counsel, and we're able to go through those and mine them for discrepancies and challenges. My opinion is most cross-examinations should be written out in advance. I mean, I've done thousands of them, and I still write them out, so I think that's best practice. You know, be prepared to pivot. But you should have a really good outline that you're going to utilize. And sometimes we'll confront their expert with covert video or social media postings because we'll undermine their claimant. Now, this is also an opportunity to get creative, right? It's crucial, I think, to use their prior testimony, especially if it conflicts with their current testimony. And here's a great example, right? We've all defended occupational exposure cases or cumulative trauma cases. And in those cases, those expert physicians have characterized degenerative changes. And you know those degenerative changes, the same ones we see all the time: chondromalacia, degenerative disc disease, herniated discs, annular tears, spinal stenosis. And they'll say, this was caused by the chronic work activity. This was caused by the arduous nature of their work. This was caused by 20 years of working at this facility, and this caused all these conditions, right? But then in a specific accident case, those exact same findings, those exact same medical experts will then characterize them as acute or traumatic findings. And they'll say, well, this person has chondromalacia in their joints, and that's because of this terrible accident. I'll say, but haven't you testified 15 times in the last 2 years in front of this court that chondromalacia is also could be the result of degenerative changes taking a long period of time and perhaps a lifetime of work employment? Oh, yeah. And if they say, no, I don't think so in this case, you can confront them with the testimony in the other cases. So you've got to do these things to make them uncomfortable. If you're just cross-examining them on the report that's in front of you, you haven't done your job. The other thing they love to do is to bring in psychiatric claims, which are really just recharacterizing pain and suffering as anxiety or PTSD and are challenging them as that occurs. So there's a lot of grounds here, and we should get creative here. The goals of these cross-examination is to undermine their credibility, to challenge their conclusions, and if possible, to challenge their qualifications. Sometimes I will be introducing contradictory evidence, and I'm going to be challenging the basis for their entire opinion. Now, their doctors are supposed to provide us with their curriculum vitae, and then we can use that to challenge them. But we've got to do more than that. right? We've got to research them. And Google's one of our friends here. So is Westlaw, some of the other online databases that we use. Look for suspensions, censures, or revocations. I've got a case in which the doctor that was selected by opposing counsel had been censured by the American Academy of Orthopedic Surgeons for not relying on correct evidence in a prior case. He was censored by his own certifying body. Well, it's a great opportunity to challenge him and say, well, in another case, you didn't rely on and use the MRI evidence at your own organization. Your certifying body says you should. Why should we consider your opinion valid in this case? How do we know what you did or didn't? You know, that's a great opportunity for us, so we should be doing that. Or a doctor who's got a checkered past, maybe drug abuse in their past or criminal behavior in their past, or suspension of their license to practice medicine, right? These are opportunities for us to go and find. So that we should be utilizing that. We should also be using prior transcripts. Use those prior transcripts to attack things, to undermine their conclusions, to challenge their use of speculation. Now, the other thing that's ripe for us to challenge and to make some case law on is the opposing party's understanding of disability estimation. Now, I'm going to shock you. New Jersey has no published standard at all for finding permanent residual disability in any case. Shocking? It should be. American Medical Association has guidelines. American Academy of Orthopedic Surgeons have guidelines. There's plenty of guidelines. Some states make up their own guidelines, right? New York has disability duration guidelines. New Jersey has nothing. There is no one standard way that physicians are supposed to estimate permanent impairment. That's amazing. And that's also grounds for an opportunity for us. And we should be utilizing that because there's no uniformity to it. There's no case law on this. One of the things I'm going to be doing in the next few months is issuing Freedom of Information Act requests to the state of New Jersey, Division of Workers' Compensation, to get records of every single judgment ever found in this jurisdiction, because, by the way, the state does keep data on that. And I'm going to take a lead on securing that data so I can run statistical evaluations of it and determine what are the actual disability estimates and findings that have been found over the last 20 years. Because I think some of these physicians depart from it so dramatically that they are incredible and cannot be relied on. All right, we also need to undermine their opinions as to causal relationship, the body parts, and the extent of disability. And I think, again, this is an opportunity for us to challenge them. We need to emphasize that they are just a one-time expert, that they have no specific definition of disability, and we're able to show by showing prior transcripts that it changes from case to case. And of course, this is where we're going to want to bring in outside proofs. How does the claimant act when they are not in the doctor's office, and how are they able to carry on their activities of daily living, and how can we use that to undermine their physicians? The last thing I'm going to touch on is we should not allow the other party to use or present hypothetical questions. Now, this has been in this jurisdiction up until I challenged it. This was routine that the parties would submit hypotheticals with agreed upon facts to the examining physicians for them to opine on the stand. And I was really the first to push back against that and say, absolutely not. I refuse to allow that. The point of them testifying is so that I can challenge their assumptions. I'm not agreeing to what their assumptions are in advance. And I think there's really strong legal arguments as to why any type of speculative or hypothetical question should be eliminated. This could be its own course on itself. I can tell you we've taken the absolute lead on pushing against this. And if anyone has any questions about this or would like my specific objections here, please let me know. I'm happy to provide them to you. But I've also, of course, put them in my book. Now, our evaluations and our physicians, when we present them, I want to present physicians who are board certified, who are ready to go and are thoroughly prepared. When I present them during my direct examination, I've fully prepared them. I've mooted the testimony with them. I've gone through the case with them. Sometimes in a complex case, I would also recommend talking to our clients. Some of my big carrier clients have medical staffs and medical directors that can help us prepare and be ready to go and give us great information, statistical surveys, published journal articles, other things that we can use to undermine opposing counsel's findings. I also want to make sure that if the witness that I'm using is unknown to the judge, they've never had them testify before, that I'm going to introduce them to this judge, and I'm going to use this as an opportunity to build them up as a future expert. Again, during cross-examination, I'm going to protect my expert. I know the objections. I am going to make sure that I'm taking care of my witness and that I'm going to let their testimony come in and ring as powerfully as it can. In this jurisdiction, unfortunately, the judges are allowed to ask questions of any witness, right? They almost act like a party in the case, and you got to be very mindful about this. Sometimes opposing counsel won't ask a good question, or they'll ask a question and get an answer they didn't expect, which is helpful to us as the defense. And then you'll see the judge swoop in and say, well, I'd like to ask a few questions, and they will fix it or rehabilitate the witness for the plaintiff. Okay, I always think when I'm litigating a case in this jurisdiction, I have two adversaries. One of them is opposing counsel, and one is sometimes the bench. So you have to be thoughtful about objecting, and you can object to a judge's questions. Why would you object to a judge's questions? Well, be careful, because you might be just annoying the judge, but you are preparing the case for a successful appeal later. By putting that objection on the record, you're preserving that issue so that later on you can rely on it in your appeal if necessary. All right, so let's talk a little bit about some takeaways and close this presentation out. We talked today about pretrials, and we talked about trials. And in last month, we talked about motion practice, and I've told you, these tools, these standard litigation tools, have become increasingly useless in gaining traction in cases, particularly in this jurisdiction where the courts routinely ignore the plain meaning and requirements of the statute and rules. So we've got to be proactive. If your defense is waiting for things to happen at pretrials or telling you maybe someday this motion will get heard, that's not enough in this jurisdiction. Now, I would also tell you that we have to go beyond just proactivity. Sometimes where cases are not getting moved or leniency becomes absurd. I've got cases where opposing counsel has been granted so much leniency and given so many continuances and so many adjournments that it's ridiculous. Have your defense counsel contact the supervising judge. And if that doesn't work, consider using a writ of mandamus to force the courts to address the issues in your case and get them moving. Again, that is necessary in a jurisdiction where things are moving so slowly. I would also say in trial outcomes, these are increasingly being based on subjective factors. You should be very mindful that judges could punish you as a non-compliant party with a high permanency findings. What do I mean by that? I mean, the parties have a legitimate dispute as to the nature and extent of permanent residual disability. And the judge weighs in and says, well, I think the permanent disability is X, and it's somewhere between your number and opposing counsel number. And they come up with their own number. Be warned. Once the judge has put that stake down in the ground, their ego is now involved in the case. And unless you have surprise witness or some excellent testimony or some documentary evidence, which you think is going to be incredibly persuasive, be thoughtful, because the judge is more likely going to find either the number that they called the case at, or maybe a little higher to teach you a lesson because they've been annoyed. So just be mindful about that. Now, sometimes you have to try cases. Be thoughtful about the fact that there is no published or uniform method for determining partial disability. And I've been at this for 20 years. I know generally what the values are for most disabilities, and we're going to be able to call it with really good predictive ability. But there still are outliers. Think about, do I need to set this case up for an eventual appeal? Should I be setting the groundwork for that? And the last thing I'll talk about is one of our things that we're working on now is to proactively secure case data so that we can create an appeal process here that's based on statistics, which I think would be more compelling sometimes than comparing reports in an individual case. All right, thank you for attending this webinar. It was a long one, but I think it was a good one because it was covering some interesting issues and some interesting stuff that's not frequently talked about. So I've got some questions here. I'm going to come over here to these questions and see what I've got. So I want to answer as many questions as I possibly can. All right, let's see. All right, sorry, I don't see any legit questions. All right, thank you for joining me today. I hope this was a useful webinar for you. Remember, this presentation is for instructional purposes only and not legal advice as to any particular matter. Thanks for attending, and I look forward to seeing everybody next month.